on YouTube and get started. Good morning. This is Judge Elisa Perez resuming the civil docket for June 12th, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nuanez, would you please call our next case?
Calling docket number 2023 DCV 1852, Rafael Garcia versus AmeriLink et al. Announcements, please.
Good morning, Oscar Lara on behalf of Mr. Garcia.
Adam Cetra here for defendants Alberto Yoshimoto and AmeriLink LLC.
Mr. Nuanez was not going to appear today. Does anybody know?
I'm not sure, Your Honor, but he doesn't have a dog in this one, so it's okay. He's not present.
Mr. Cetra, are you okay with that?
I have no objection to proceeding.
Okay, so we're here on defendant's motion to vacate protective order. Mr. Cetra, you may proceed.
Thank you, Judge. And just, are we on the record presently?
So you're aware, as long as Ms. Deborah Lee, the court reporter that you see on the screen is there, we are always on the record.
I only see 3 videos at a time, so I didn't see her. Great. And Judge, just for sake of time here, how much time do we have to present our side? And
I don't have
so
a
that
limit.
Okay. And so we're here on the motion to vacate, Judge. And I'll also say that I'd probably like to reserve at least 2 minutes for rebuttal if necessary.
Mr. Cetra, as I've mentioned, I'm not giving you a limit. Please proceed.
It's okay. Thank you, Judge. So we're here on the motion to vacate the protective orders and the motions to quash that were filed. Essentially what happened is the plaintiff was noticed for deposition on March 15th, and I have a pretty solid timeline here that I'd like to lay out, which kind of outline the various conversations that have occurred with, I believe, the previous lead attorney, who was Manuel Lopez, and who indicated that the depositions couldn't go forward in February because the plaintiffs intended to amend at that time. Alberto Yoshimoto and and AmeriLink LLC were the only defendants at that time. Afterward, I believe in January, at some point in January, there was an amended petition that added in Swift Transportation and Daniel Webster Sneed, who were represented by Mr. Hernandez. So what I ended up doing was filing these deposition notices for March 15th. They were filed on February 27th, in line with the scheduling that was understood from the conversations that I had with Mr. Lopez. Now, after 2 days later, well, actually, let me walk it back, because I also want to highlight something on that day, because those notices were also mailed to Mr. Lara, to Gloria Hasso, to Sam Legate, along saying, here are the notices for deposition. Let us know if you want to discuss. And there was no, and it's an open invitation at any point to discuss that. And I didn't receive a response. Instead, 2 days later, we get motions to vacate, motions to quash, rather, on those depositions, stating that there is no issue with the time and place of the deposition. And this is directly from the motions as they were filed, which specifically say, well, let me rephrase it. It says, does not object to giving his deposition. They object to the date and time. They raise something from their petition, particularly in the plaintiffs, on the one for the plaintiff, I believe, stating that in their original petition, there's a request for depositions that's also there, which was also discussed with Mr. Lopez. Mr. Lopez indicated that he could not agree to producing the plaintiff before he took Mr. Yoshimoto's deposition. We talked about doing them one day, taking Mr. Yoshimoto's one day and having his client immediately afterward. That issue again was raised by Mr. Lara down the road, and I let him know, go ahead and send your notices. happy to produce it. Mr. Yoshimoto will make himself available with appropriate notice, meaning don't do it the day before, just give enough time. There's adequate notices provided. That's what the rules provide. They filed the motion to quash on both parties that were going to be deposed. One of them was my client's employee, and they got a protective order on that. And so I'm going through a little bit of procedural history here, just to kind of lay out the timeline, Judge. There is no conflict, and there has not been a conflict that has been raised. Secondly, with regard to the motions to quash, just another thing to highlight is if you object to the time and place, then you have to provide your available dates. That's not provided either. So after the motions to quash are filed, the co-defendant files their answer on March 1st. With no issue of taking it on the 15th, it was understood that perhaps Mr. Hernandez's client may object to the time and place, and we would have to reset those, but they did not. They said, we're happy to proceed. March 15th works. Please send us everything that you've exchanged thus far in the case. I did so, understanding that these were going to proceed. On March 6th, we have a hearing with the visiting judge who orders that we confer on available dates for the plaintiff's deposition and let the court know so we get, and let the court know if we were able to reach an agreement or not so we could get on the docket the following week. Same afternoon, immediately after we got out of the hearing, we conferred, did not receive available dates from Mr. Lara. A lot of it was, why do you need to take the plaintiff's deposition? What information are you trying to obtain from that? And discussions about insurance and what insurance was available. And but really it's focused on the reason for taking the plaintiff's deposition, which we're entitled to take. On March 8th, which was 2 days later, the court was notified that the parties were unable to reach an agreement on an alternative date or on that date. And the hearing was requested we were instructed by the judge for us to be able to have this issue decided. The following Monday, I believe on March 12th, so I believe March 8th was a Friday, we sent out the notice to the court, the note, just kind of apprising the court of the developments. March 12th, I think March 12th at 4:42 p.m., we got a response that the court was not available and had no availability until March 20th. On the following day at 2:20, we received an email saying that the court had granted both motions and signed off on the protective orders. Now, that's what we're here about, is on these protective orders that were filed, because if we notice the deposition of the plaintiff, then we're in violation of the protective order. The protective orders require evidence, Judge. That's very clear from the law, and I will also address some of the issues with the response that was filed by the plaintiff on this. They never stated a conflict. There was no time conflict. There never has been. This is pure and simple resistance to discovery. The response filed by plaintiff's counsel has no law. It talks about the lawyer's creed, but doesn't address the deficiencies in both their motion and their request for protective order, because no evidence was presented and there's no valid basis for that motion to quash, because they didn't even meet that low burden of providing dates to satisfy an appropriate motion to quash. With regard to conferring, I've conferred multiple times with Manny Lopez. I've conferred several times with Mr. Lara. I believe opposing co-defendants counsel rather has also requested dates. No dates have been provided. We've been stonewalled on just taking something as simple as a plaintiff's deposition. The person who filed the lawsuit and brought everybody in this is the one where we're meeting resistance on just getting what the heck it is that we're here about. And the reason why it is so critical, Judge, is that there's just out of the disclosures, there's evidence that's showing that the plaintiff in this case is the one who swerved his truck across 3 lanes of traffic and crashed into the other vehicle. Now, with regard to the saying that I don't want to confer and the exhibit that was attached, I would just ask the court to consider the fact that it says there's a pending motion, happy to confer with you. That is not a refusal, and it was represented to the court at the last hearing, and I believe the court also accused me of making various misrepresentations, factual misrepresentations, based off the things that were being provided to the court and the information, misinformation that was being provided to the court by opposing counsel. I was clear. There's a pending motion regarding this very issue. Happy to discuss once the court has taken it up. Unfortunately, we haven't been able to take it up until today. And so I'm asking the court to apply the law, to vacate those orders so that we may proceed and get these depositions noticed. And that is all, Judge. I appreciate it. Thank you.
Let me just ask before I hear from you, Mr. Lara, the 2 orders that are the basis of your request, Mr. Cetra, those are the March 14th orders granting the motion to quash and motion for protective order, right? That's what we're talking about?
And that's exactly what we're talking about, yes, Judge.
In terms of, so I'm reviewing the order here, order to judge and agree, plaintiff's motion to quash defendant's notice served on February 27th, and motion for protective order is granted. Let me go back quickly. Let's see. The motions to, okay, go back. Motions to quash. Let me go back and look at plaintiff's motion. Okay, so the requested relief in the motions to quash and for protective order, plaintiff prays that after notice and hearing, the court quash the notices of the deposition of plaintiff and enter a protective order to reschedule the deposition to a date and time which would be reasonable and convenient to all parties and counsel involved in this lawsuit. All right. And I just wanted to clarify because, of course, on those 2 orders, that language is not the most specific, so I wanted to relate it back to the actual motions. I think, and I invite you to correct me, Mr. Cetra, that there is nothing in terms of the motion to quash, the motions to quash, and the respective orders. I feel like I'm hearing you to say that you can't move forward at all in terms of rescheduling a deposition because there's a protective order. Am I wrong on that?
Well, Your Honor, yes, when it's taken in a vacuum. However, when it's coupled with a refusal to provide available dates by the plaintiff, and I would invite Mr. Lara to please share with the court what dates and availability he's provided, then yes, because then there's no mutual agreement, and then that forces the issue, and you're unable to conduct discovery. And so, on the one hand, they can unilaterally send out written discovery and then compel a response, which the law provides. And then on the other hand, you need their permission to be able to take anybody's deposition. And so when it's coupled with that, yes, Judge, and it's the effect of that, of the language in there, which seems, I guess, in a vacuum, yeah, it makes sense in a vacuum. But when coupled with what we're dealing with, And the fact that there's been no mutual agreement, despite multiple efforts, multiple attempts to just get something as simple as the plaintiff's availability, that's what we're running into.
I just want to
And
make
so
sure
the
that,
option, oh, I'm sorry, Judge.
I want to make sure I'm clear that I understand what the parameters of this order are, right? And because I feel like, and I may be misunderstanding, I feel like I'm hearing from you that there is, because of the March 14th orders granting the motions to quash and protective order, that you all are prevented from engaging in any more communication to reschedule. That is not what the court's order says. Albeit I would agree the language on the actual orders are not as specific, but they do relate back to plaintiff's motions. And so the protective order, obviously the court granted the cancellation of the depositions for the reasons that plaintiff stated in their motion. And the protective order solely was to order, I guess, that a reschedule of those two depositions take place, assuming via some conference or mutual agreement amongst the parties. Okay, so that's what I am understanding. The order that you are requesting, the orders that you are requesting be vacated.
Well, I guess what I'm also bringing up here is that these were filed, and I understand that the court signed off on those. And those motions in themselves, first off, should not have been filed because that's textbook resistance of discovery that have no legal basis. And secondly, when we requested a hearing on that very issue, we were told that the availability of the court would not happen until March 20th. And we have an email from the court coordinator indicating that. And then the following day, prior to the deposition, we just received, hey, these are granted. No evidence is considered. There's no hearing. There's no opportunity to be heard. And so those issues would have been great to bring up prior to, Judge, but now we're after the fact. And then when we have somebody that's not providing dates, and again, I would invite plaintiff's counsel to share with the court what dates have been provided, what their availability is, which has never been done at any hearing or in any pleading or in any communications or any correspondence, despite multiple attempts to do so. That's what we're running into. And the other thing is, how are motions being and protective orders, which require somebody to meet an evidentiary burden, they require evidence that's in the law about what you have to prove if you're requesting a protective order in a civil case. None of that's there. And so we lose our opportunity to conduct discovery. I'm wanting to reinitiate it. I've tried to reinitiate it. Here we are. And so I'm asking the court to vacate the order so that we can proceed, because if you cannot get the agreement of the other party, the rules still provide you with the opportunity to go and seek discovery. And that's the mechanism that's available to the parties. So I can't notice a deposition unless they agree, but they don't give you dates. So you're just stuck in a lawsuit indefinitely without the ability to conduct meaningful discovery in the manner that you choose.
Well, if you're experiencing so much obstruction from any party in this case, couldn't you file a motion to compel the deposition based on their refusal to reasonably come up with a date with you?
Yes, Judge. And that's something that would occur once these are vacated, because then those attempts go forward. We don't reach it, then we compel the deposition and we go from there.
Okay. All right, Mr. Lutta.
Thank you, Judge. With respect to, just to briefly respond to Mr. Cetra's representations that we refuse to provide dates, that initial conference that we said, I just explained to him that we weren't available on 15th, and I think the other date that he was looking to try to get a deposition was like on the 18th or 20th of the of March, and those were just dates that unfortunately we were not available. I think I expressed that we would find availability in April. But he refused to look at dates in April, and that was fine. And wanted to proceed with those motions. And then after that, we never had any correspondence or requests for depositions dates after the court granted the motions to quash. We are more than happy to confer. In fact, that's why I attached to my response was before even hearing this motion, I said, hey guys, something is simple. Let's just set up a call. Let's talk about all this. And we're not with Mr. Cetra, but with Mr. Hernandez or somebody from his office. So pull up our calendars and start picking dates. Let's just talk about it. That's really what you were trying to do. And that's really what you're supposed to do, Judge, because otherwise, unilaterally noticing depositions without conferring whether they're available on those dates, we have no problem presenting Mr. Garcia for his deposition at all. And especially when we requested for depositions first in our initial pleading, we have no problem just blocking out 2 or 3 days to just knock out all these depositions that we need to do. And that's where I just wanted us, hey guys, let's just let's look at our calendars. And then once we look at that, try to confer with our clients and try to make it all work like we're supposed to do. And that's all I was asking for. And that's why my response was the court properly granted the motions to quash and motions for protective order. And all we want is just an opportunity to just set up a time, which I haven't had any issue with Mr. Hernandez. In fact, there's another case before this court where we were just trying to, and there's multiple other attorneys on that. There was, I think, a couple more. On Friday, this past Friday, I just said, hey guys, let's all meet on Monday at 4. And everybody said, sure. And there we go. We met on Monday at 4, and then we coordinated dates for depositions. And that's all we're asking for, Judge. That's all we need. That's how we're supposed to be practicing. And if somebody is actively refusing, which I don't think anybody is, then there is remedies. You can file a motion to compel. But that's not been the case here, Judge. And that's all I'm asking for, just to allow the parties to set up a time and cooperate and coordinate deposition dates. And I know Mr. Hernandez isn't here, but I think he'd be in agreement with that.
Anything else, Mr. Lara?
No, that's all, Judge.
Mr. Cetra, anything?
Yes, Your Honor. This is once again, and I'm going to remind Mr. Lada that with regard to I think he was talking about the lawyer's creed at one point and the duties that are imposed. And so I talked to him about the affirmative duty to make sure that all the factual representations that are being made to a court are truthful. And at this juncture, Judge, what I've asked for are dates, and he has never provided it.
Can you tell me?
Co-counsel has requested, the co-defendant has
Cetra?
requested dates, never provided it. He cannot
Mr.
provide a single
Cetra?
instance
Mr.
when he's done
Cetra,
so.
can you stop talking when I address you, please? I need to ask you a question because you keep going on. I want to know the dates after the protective order was granted that you communicated with Mr. Lara about scheduling depositions.
I discussed it. You're saying after the motion to vacate was granted, or after you granted their quash?
Correct, or even after the actual, whenever it is that counsel became aware that those initial deposition dates were not going to be workable, I want to know on what dates and what communications you had with Mr. Lara and or Mr. Hernandez about rescheduling these depositions.
We had phone calls on, I believe I sent emails on those as well, and I'll find them.
Are they part of your motion? Are they?
No, they are not. They are not.
Okay, go ahead.
And so I know that I conferred with him in March We conferred again, I believe, at some point in April. I don't have the exact dates here, Judge. I've got to go dig through emails. I know that there are several times when he's been asked. And so is the court suggesting now that we confer and just get this nailed out? Is that what the court is asking us to do? I'm just trying to understand because I've reached out and had multiple conversations with him regarding this case. And every time I've had a conversation with him regarding this case, the matter of depositions have occurred. And we have yet to receive a single date of availability from those multiple requests. So I talked to him in March. I'm going off the top of my head here because we had telephone calls on my cell phone. I think I called him on his cell phone. I don't know if he recalls when we talked. And so I would have to go through my cell phone records to find those and dig through text messages to find his. I mean, I do see that on a couple of them, I sent an email afterward as he had requested. So we've been in correspondence, but we've just been unable to get something as simple as a date. That's what it's coming down to, Judge. And this protective order is the barrier to being able to take a deposition
So
if
I will
they're not going to
stop you
provide
right
dates.
there and remind you that the court is not in agreement with your representation that the protective order precludes any further discussions of rescheduling. In fact, the protective order specifically addresses the relief requested by plaintiff to order a rescheduling. The protective order, as maybe poorly worded as that is, Mr. Cetra, if you read the plaintiff's motion, says they were requesting a protective order to reschedule these depositions. So the court is absolutely not in agreement with your representation that you are precluded by this protective order from communicating. And as you're representing to me today, you have made multiple efforts. I see Mr. Lara has been shaking his head. Frankly, you haven't provided the court with any specific documentation that has been done. So whether Mr. Lara is disputing it or not, I don't know. I don't know what you all talked about. What I know is on the record right now with your motion, I do not have any evidence of that these ongoing efforts have been made. Okay.
And so evidence is required on my side, but the plaintiff who obtained it does not need to provide evidence. Is that what the court's ruling is? Because it seems like the court's already made.
Seems is not what I am saying, Mr. Cetra. You continue, and this is an ongoing issue. You continue to say the court is suggesting something. My question to you was, when did these communications happen? And you go into a long explanation of cell phone records. You don't know when. I'm asking for specifics because I want to know if plaintiff is being obstructive and you are making efforts to reschedule these depositions. I want to know when those are. I want to see that.
I see March 20th. There was correspondence between us here on March 20th, which is afterward as well, because we did discuss a coverage issue on the March 6th, and I called them with an update and requested, again, deposition dates in that phone call. I believe I sent an email out as well after we had a subsequent conversation as well in April. And again, it was brought up. I think the nature of that discussion was also for us to coordinate discovery responses, which the court handled in the compel. And I sent an email to the effect of, hey, we're willing to work with you here. So to the extent that it's supposed to be represented that we're not willing to work, we talked about giving extensions on both sides and just getting to the merits here of this case. And one of the, once again, obstacles that we're facing here, Judge, which I would invite Mr. Lara to once again just provide the availability. I mean, that's all we need is his availability so that we can get the ball rolling here. There's never been a fixed date that has been provided. I'm happy to send an email after this. And so if we do all that, okay, does the court want us to send a notice to the court that it's been done and then that'll get rid of these protective orders or what? I mean, I'm trying to understand because a protective order is a specialized legal device that requires evidence that has to meet a certain threshold. None of that's met. It's granted. It sits over us. They don't provide dates, so no agreement can be reached. Multiple requests are made. March 20th, again in April. So what are we to do at that point if we're not receiving the information for us to reach that agreement?
So, well, anything else on, yeah, I believe you asked for rebuttal. So do you have anything else, Mr. Cetra?
Yes, Judge, and to the extent that the court is unable to rule, or is going to uphold motions that are filed without notice, without hearing, without evidence, and then require evidence in order to vacate the motion that required evidence in the first place to be granted, and then is going to compel discovery from one party, and then order a 5-day timeline, regardless of how extensive the requests are, or the inconvenience of the part, things that would be factored in when the court makes that order. I didn't complain. We got it done. Took a long time over those few days, but we got it done. And Mr. Lara represented the court that every answer was provided fully. So we've complied with the court's orders. And what we're understanding here is that one party can use law to enforce their rights, to obtain information that they're entitled to obtain, which I don't disagree with. And then another party doesn't get notice, doesn't get hearing, doesn't even have an opportunity to take something as simple as a plaintiff's deposition, and then is required to present evidence when no evidence was provided on the order that the court issued, along with a motion to quash. Then, Judge, I mean, that seems like we're operating on two different sets of essentially rules here. And I think my client's entitled to a fair trial, and I think my client's entitled to have the rules apply to him, and for him to be able to obtain, or for them to be able to obtain, basic discovery that they're entitled to obtain. And so, to the extent that the court isn't going to, then I'm going to just ask that we're happy to file a very straightforward, simple motion to recuse, so that we can start afresh somewhere else, because it appears that there's an unwillingness here to apply the law when we're asking for it to be applied. And then we're seeing over here that the law doesn't apply on relief that's granted, but the law applies when they want to push stuff through. It doesn't make sense from our perspective. And so I'm going to ask, if the court is unwilling to, then we would be happy if the court will take this up on advisement, this issue, and I'm happy to file the motion to recuse. And I think that just moves everything, and we can have a fresh pair of eyes on all this.
Is that the extent of the time you need on your motion, Mr. Cetra? Mr. Cetra, can you hear me?
Yes, Your Honor, I can, and I'm checking my notes here, so bear with me so I can consult with my notes. That is at this time, Your Honor, and to the extent that there are going to be additional submissions, we will be preparing those and sending them and filing them with the court as appropriate.
With respect to this motion, are you asking to submit something in addition on this motion to vacate?
Well, I mean, I've laid out what the points are, Judge, so you make your decision, and then we will take it from there.
Okay, sounds reasonable. I am again asking with respect to those communications that you have represented have been made, communications, I think you referenced to March 20th. I'll leave the record open until noon tomorrow for counsel to provide. I did see there was some emails. I'll have to go back. I don't know if those are going to be the ones you are referencing, Mr. Cetra. But I'll leave the record open until noon tomorrow for you to supplement your motion with any of those communications. Since basically the noticing of those initial depositions until today of when you've communicated with Mr. Lara or anyone over there in his firm about the rescheduling of depositions. And that is, I'm not talking about discovery outside. I know we had some discovery matters responses to discovery, things like that. I'm strictly talking about the two depositions that were made the subject of the motions to quash and this motion to vacate today. Okay. If you will please file them with the clerk as a supplement, serve counsel, and I will have a ruling for you after I receive those.
One thing briefly, Your Honor, if I may.
Yes, sir.
During the time that I was visiting with Mr. Cetra with respect to the discovery extensions for his client, Mr. Cetra did represent to me at one point, I want to say it was late March, like March 20 something, or on 27th or first week of April, that he was planning on withdrawing from the case. And he represented that to me. It might have been April 4th when he expressed that to me, but he did express that that was something that he was likely happening to do. We never saw that motion, but that is a representation that he expressed to me. I just want to let the court know with that. When also, we are still open to just visiting with Mr. Cetra and Mr. Hernandez to just sit a time and visit and schedule depositions.
Okay.
Thank you.
Well, then, Mr. Lara, again, I know the invitation to supplement the record. I know I directed that to Mr. Cetra to the extent, again, if you feel that that is somehow related to the motion to vacate, I invite you as well to supplement your response. Again, you have the same deadline of noon tomorrow, and that is when the record will close on the motions to vacate or the motion to vacate.
Thank you, Judge.
Anything else?
That is all for me.
Mr. Cetra?
No, I don't have anything further on this. How does the court want us to provide any evidentiary exhibits?
As I mentioned, you can provide a supplement to your motion and file it, e-file it like you would any other pleading. So there is service on the parties. With that, I would say provide the courtesy copy to the court via email to Ms. Hernandez. Please make sure it's filed. I'm not going to look at anything that is not filed, the district clerk. Okay.
Okay, to the extent, Judge, and this is one of the things that, and this is, I think, maybe one of the things that's is that I believe, and I need to confirm this, that our phone rep system may have recordings of this that I would have to retrieve of these phone calls. And so does the court want me to file those or provide those alternatively? I can also file it under seal so the court can review those in camera. If so, doesn't matter to me. It's just, I want to know how the court wants to do that in the event that there's audio submissions, things of that nature.
I'll leave that up to you. You're the attorney. The deadline is noon tomorrow.
Thank you.
Okay.
Anything else?
And that is all.
That is all, Judge. Thanks.
Thank you for your time. You are excused. You can get off of YouTube, Mr.